Get up to 2 months of free podcasting service with Libsyn. Check out the show notes for your promo code to get started podcasting today.
Even with a traditional family, that's not blended, that's not always the case, right? You have different relationships with your children, especially as they become adults, where you might have a child that's estranged. You might have a child that requires more, that might have special needs that, you want to be able to plan for and protect them, in a different way. So blended family or not, fair does not mean equal, and, vice versa. Equal doesn't mean fair. So we want to make sure that we're taking into consideration these different dynamics. And that's the benefit also of doing the life and legacy planning session, because we talk about, okay, what are the family dynamics?
Welcome to the Unlocking the Club podcast, where we host honest and direct conversations about journeys of access, personal truth, and reclaiming space. We share our truth so that you can find the key to own your truth, honor your journey, and reclaim your space. Grab your keys, your wallet, your phone, and invite your friends to meet you at the club. Here's your host, Angela Taylor.
Hello, everyone, and welcome to a very special series of Unlocking the Club, where we explore one of the most important yet often overlooked conversations that we can have: estate planning and elder care. I'm your host, Angela Taylor, and I want you to know that my inspiration for this series was the fact that over the past few years, my family, friends, and I have all learned the hard way about the critical importance of having a will or trust in place. When unexpected moments arise, not having a plan can leave families vulnerable, and I've seen firsthand how it can create chaos during already challenging times. Recently, I conducted a poll, and the results were eye-opening. 80% of people between the ages of 20 and 65 do not have a will or a trust in place. Even more striking is that most of those who do, in fact, have a plan in place actually only took action after experiencing a tragic event. National data supports this as well, with studies showing that a significant majority of adults, particularly within Black and BIPOC communities, have not taken steps to secure their legacies. And when we fail to plan, we leave our families with legal battles, financial burdens, and emotional stress that can take years to untangle. That's why we're dedicating an entire 12-part series to unlocking the essentials of estate planning. Together with two brilliant legal minds, Shane Jasmine Young from Young Law Group and Verlena Green-Toluska from BDG Law Group, we'll break down what you need to know about protecting your assets, building a legacy, and making sure your loved ones are cared for when it matters most. Our goal in this series is to equip you with the knowledge and the tools to take action now before life forces you to. Whether you're just starting out or you're navigating the complexities of caring for aging loved ones, these conversations will give you the clarity and the confidence to plan for the future. So grab your notebooks, tune in, and let's unlock this critical conversation together. Welcome to Unlocking the Club's special series on estate planning and elder care. Welcome back to Unlocking the Club and our special 12-part series on estate planning and elder care. Today, we're going to talk about estate planning for blended families. Blended families come with unique challenges when it comes to estate planning, ensuring that all children and the spouses are taken care of while minimizing conflict requires special attention. Today, we'll dive into how to effectively plan an estate in a blended family and avoid common pitfalls. Joining us to discuss this is Shane Jasmine Young of the Young Law Group. Shane, thanks for joining us.
Hi, Angela. Thank you so much for having me.
Thank you for being here as well and continuing this conversation about estate planning and elder care. And we talked about specifically blended families, but I think that it's relevant for all families. Like, why is it important for those with children in particular to really focus on estate planning?
This is where I see some of the most common and horrific mistakes being made when it comes to estate planning, unfortunately. And that's one of the reasons why, as part of my practice, we focus on families with children, blended families included, because there's all these different dynamics and family dynamics and relationships, that go into, these really important considerations and decisions when it comes to planning. So, as you mentioned earlier, I am the mother of five daughters. My husband and I are actually high school sweethearts. And so our oldest daughters are now, well into their 20s. They're law students. And my youngest is 13. So I still have three minor children at home. But several years ago, when all five of them were much younger, my husband Charles and I were out on a date. So this is my date night story that I promised I'd share. So we're on a date and we're having a good time. The girls were at home with a babysitter. And, we were talking and, I just started thinking like, what if we didn't make it home? What would really happen in this situation? And here I am, an attorney, and, I realized at that moment that we didn't have a proper plan in place for our children, because the reality is if we didn't make it home, something happened to both of us, accident or otherwise, the cops would show up to our home. They'd see that they were there with someone who didn't have legal authority to care for them. They would take our five daughters out of our home into the care of the authorities, to Child Protective Services. And Child Protective Services, CPS, would be, fostering them through their foster program, probably be split up because, who can take on five children at one time? And they'd have to go through a court process, a family court guardianship process, for a judge to decide who can take care of our kids in the short term until a long-term guardian would be able to come and step in. And the laws are really that only blood relatives can step in and serve in a short-term guardian position. Well, here we have a lot of family members locally that are blood relatives, but there are certain family members that I would never want taking care of my kids for 5 minutes, let alone, days, weeks, months, potentially, and certain family members, by virtue of their relationship, I wouldn't want raising my children. So that was really scary for me to realize that, oh my gosh, this is the reality if we don't properly plan. And so from that point forward, of course, I made sure that my children had a proper guardianship plan in place. And that's something that I offer to all clients. Is part of our estate planning packages include guardianship and children's protection plans, kids protection plans. So the planning for that, for the children, each child essentially has like a mini plan within your overall plan. And each of those plans includes short-term guardianship nominations. So the short-term guardians are people that live in your city, that can get to your children within 20 to 30 minutes, people that your children are familiar with. So it doesn't have to be a family member. It could be a neighbor. It could be, a coach, a friend, family members, of course, but people that they're familiar with that can get to them so that the cops aren't the ones showing up and taking them out of school or taking them out of your home. So that's short-term guardians that kind of fill the gap until a long-term guardian can arrive or until you're able to make it back home. So the long-term guardians are those that would step in to raise your children if something happened to you and you weren't able to come back to raise your children. So long-term guardians are people that you get to decide. They don't have to live, locally. They can live out of state, but there are circumstances and considerations. Would you want your children to be raised in another state, or would you like them to remain, where they are? So those are people, things to think about as you're identifying who would be on that list. But really the bottom line is, who would raise your children as closely to how you would raise them if you were here? So who will uphold the values, that you would want to instill, work ethic, education, community service, if you're religious, if you want your children to continue to observe your religion, your culture, family traditions, things like that. So making sure that having medical powers of attorney for your children in the event that, if you're traveling, that whoever's taking care of them can go to the doctor, take them to the hospital if need be. So those are nice things to have, just, peace of mind. And then we also include ID cards for parents. So you keep these cards in your wallet so that if any thing happens and there's a first responder type of situation, that the first responders can follow the instructions and make sure that, the right people are stepping in, and it's not a situation where the authorities are taking over.
I got to, I'm not a parent, but I had never thought about, right, the distinction between like having someone, again, that short term, someone, a coach, a teacher, someone in the church that you can trust to, in that moment, if the kids don't know what's happening, as opposed to being child protective custody or something like that, to have someone who's familiar to them, versus the big picture of, in your absence, who you would want to have taken care of your children. But Shane, you also mentioned something that I want to make sure I don't step over. Because as we're talking about this really important topic throughout this 12-part series, I want it to be clear that for all of us, whether we have something in place or not, don't judge yourself or don't judge others. And I appreciate you sharing the date night story, that you as an attorney hadn't had something in place, but that, as you've talked about in our previous episode, our episode actually launching this series, how important it is to start doing something today. And so for all of you that are out there listening or watching this on YouTube, like, don't rehash what's happening in the past or what you have or haven't done. Just know that you have an opportunity in this moment moving forward to rectify the situation and put your assets and your legacy in a strong foundational place.
Right. And that's an important point to make, because it's not too late. If you are hearing this and you're receiving this information, there is no shame, because some of those statistics, that you shared earlier at the beginning of the segment, the majority of us don't have a plan in place. And even those that do don't have a proper plan. So, as you can imagine, I see a lot of that. And the majority of the clients that I do serve, they don't have anything in place. That's the most common thing. So there's no judgment. I always, I put families at ease, because I say, look, I'm here to support you, and I'm just glad that you're here, and that now you're taking all this information in, and you're empowered to be able to make decisions. It's a different story if you don't have access, or you don't have the expertise or the education, but it's available. So, thank you again, Angela, for making these resources available and sharing this information as part of this series, because it really is so important.
Oh, you're welcome. You're welcome. Well, and one of the things you've talked about is one of your priorities, your specialties of your firm is with families and family planning. What are some of the unique challenges, Shane, that you've seen with blended families? And we're seeing more blended families, right, coming than ever before. What are some of those unique challenges that they face when it comes to estate planning?
Yes. And, in these times, that's the reality. Most of our clients, a lot of our clients, especially, this generation, not so much the older generation, but we're seeing, so many more blended families coming in and doing planning. And when you have a blended family, there are a lot of, complications that can arise if you don't have planning set up. And so it's even more important to outline and have provisions in different circumstances. Like, okay, well, if I have children and now I'm married and my spouse also has children, if I were to die first, then let's talk about that situation. What do we want? Do I want my children to receive, their inheritance or a portion of their inheritance, so they don't have to wait until their stepfather, passes away for them to receive, their inheritance, and vice versa. Also, with blended families, another really important feature of planning that we can include is where we're able to designate at that first death. If the husband and wife or the spouses don't die together, if the couple doesn't die together, but one predeceases the other, then we can actually have protections. We call it a family trust, so that assets are held for the benefit of, these beneficiaries, where the surviving spouse can't just change everything and disinherit. If I were to pass away first, my new husband can't just disinherit my children and leave everything to his. And that's a common thing that happens when you don't take that extra step of, planning for that particular dynamic. The default is the assets all go to the survivor, and the survivor can make whatever decisions he or she wants and can disinherit the other spouse's children or beneficiaries. And we've seen that happen play out, unfortunately, where sometimes things are not designed properly, or they have, they haven't updated planning. And so they have, a specific person or party that's still listed as a beneficiary, but that wasn't their intent. So that goes back to your point, in our conversation earlier about how often should you be looking at your planning? Like pretty often, right? Because things change, relationships change and your life changes, the law changes. So being able to make those adjustments and update your planning is so important.
Yeah, and then as all these variables are changing, how can someone ensure that all children, including stepchildren, are treated fairly in an estate plan? And as I'm saying that, I think back to, and I know you're familiar with your background as a student athlete. Tara Vanderveer, the legendary coach at Stanford for women's basketball program, always would share with us in practice that she's going to treat us fair, but not equally.
Right.
And, the beginning, I was like, what does she mean by that? But now I completely get it. Fair to each individual. So how can we make sure that all children, stepchildren, and other children are treated fairly in an estate plan?
Right. And such a great question, because sometimes, the default is, with a traditional family that, okay, well, I've got 3 kids. And so each child is going to get a third, because they're equal. Well, even with a traditional family, that's not blended, that's not always the case, right? You have different relationships with your children, especially as they become adults, where you might have a child that's estranged. You might have a child that requires more, that might have special needs that, you want to be able to plan for and protect them, in a different way. So blended family or not, fair does not mean equal, and, vice versa. Equal doesn't mean fair. So we want to make sure that we're taking into consideration these different dynamics. And that's the benefit also of doing the life and legacy planning session, because we talk about, okay, what are the family dynamics? Oh, okay. So this particular child, has this situation. All right. Well, now your new spouse, and now you're kind of combining things. And okay, so now you're dividing up, amongst like all of the children, which, it's not going to always be equal. It's not going to be the same, but each child will receive according to how you, as the parents and the grantors of the trust, decide and determine what, is right for your family's situation. So I tell clients all the time, there's no judgment. There's no, need to feel bad about decisions that you're making, because these are your choices. It's the life and the estate that you've created, that you get to decide how things, play out. And, so again, there's no judgment. So if family comes in and they're like, well, we've got, these 4 kids and we're not going to include, so-and-so, okay. I have certain family members where, thankfully not my children, but, other family members that we don't have any contact because, it's just, it doesn't work. So, and I'm very candid with clients as well. I'm like, look, everybody has their situations, everybody has those family members where, you've got dysfunction, or people don't get along, or, you're disinheriting because of, one reason or another. And this is a no judgment zone. We're here to support you and guide you and, be a resource and empower you to make the decisions, for yourself that, and your family that are best for you.
Really good advice. What role can prenuptial agreements or postnuptial agreements play in estate planning for blended families and just new families?
Mhm. So great question. And each state is a little different when it comes to, family law. And that's kind of where there's an intersection of like family law when we talk about prenups, divorce, custody, and estate planning. So there is some overlap. And what I do recommend for clients, that are not currently married, but they are looking to get married. We get this call a lot, like, okay, we're getting married in June. What do we need to do in preparation for that? And one of the questions that I ask is, okay, well, do you plan to have a prenup? And, if they haven't had the conversation, I say, have the conversation, and, prenup, it doesn't have the same stigma as, years past. Really, prenup it's an agreement, and we're just coming to an agreement so that if there is any type of issue in the future, we both know where we stand. And it's really just a reality of, sometimes things don't work out. We're not setting ourselves up for that, but we want to make sure that if there is, something that comes up, that we're on the same page and we're protecting each other really in that. And so I always recommend having the conversation first of all. And if they need a little help or counseling with the conversation, I'm always happy to be a resource. But if they do want to move forward with a prenup, that is something that we can assist with, and we do handle in our office. It's best to do it before you get married and before you put your estate plan in place. So prenup versus postnup, or premarital agreement versus, post-marital agreement. It's always better to do the pre, right? To do it ahead of time. And we wanted to have the prenup in place at least 30 days before the wedding. So if you're planning, on a rush basis, the best practice is to plan ahead so that neither party is feeling pressured, into signing a prenup, because that could be an issue later, if it does come in front of a judge. So having the time to really talk through these different contingencies, these different ways of, dealing with a potential, separation, and being clear as far as how you want those assets and property distributions set up. So that would be, my recommendation is to have the conversation, first of all. And if it is something that you are wanting to move forward with it and try to have that in place at least 30 days before you actually get married. And as far as how that plays into your estate plan, we can actually start the process of planning even before you're legally married. It's good for us to finalize the documents, as a married couple. But even if you put a plan in place and sign it before you get married, we can make amendments and updates, relatively easily. So it's good to have the conversations earlier, have the meetings, get the ball rolling earlier versus later.
Here, this has popped into my mind, and the current generation, it's not the same, but I know for our parents' generation, oftentimes the wife may not have been able to have the mortgage in her name, credit in her name, or many other things. Like in that particular situation in families where her name may not be on a deed for a house that was purchased 40 or 50 years ago, what are some things that blended families or other families can navigate as well?
So, and it's actually more common than you would think, right? So, one thing that families like that can do is make sure that if someone's name is not on the deed, that you have that person designated as a beneficiary of your estate plan. And it's actually best depending on the relationship, So, like if it's, my property, and I'm leaving my property to my children, for example, it's better to not have them on title now, because anytime you have, a joint ownership type of situation, whether it's real estate, bank accounts, sometimes people do that because they think, oh, okay, well, I would do that because if something happens to me, I want, my child to already have access to the money in the accounts and things like that. I always, I do not recommend that. Joint ownership can be dangerous because if that other owner has a creditor, if they're sued, if they get a divorce, that is an asset that belongs to them legally. Even though you might say, well, it's mine, but I'm just putting you on there. No, legally, they are an owner, and those assets can be taken away by third parties, creditors, a divorced spouse, assets that actually belong to you. So be very careful about joint ownership. The other thing is you do get benefits of designating your child in that situation as a beneficiary versus putting them on legal title, because we're able to get what's called a step up in basis. So there's tax advantages. So we don't get hit with like a capital gains tax. And also we can avoid certain other taxes and fees, transfer fees, estate taxes, by properly having it structured within, your estate plan. So these are all very specific dynamics box. And the answer or the recommendation will vary depending on the situation and what the family's goals are. But that's another opportunity to have a conversation ahead of time versus just making decisions because, so-and-so told you to do that. I hear all the time, oh, I got advice. And I'm like, was it from an attorney? Was it from an estate planning attorney? Who is this person that you're just following?
So I'm thinking of the Holiday Inn last night and thinks that they want something on YouTube.
Yes. So please utilize the resources and don't just do things without, the proper guidance and without, the recommendations of someone who actually has that expertise. I had you brought up the example of real estate, and I had a friend, unfortunately, that lost her husband unexpectedly, and they have 2 young boys, and she's in her 40s, married. Her husband's name was on the deed and she wasn't, and they didn't have an estate plan. So now they had to go through, she and her sons have to go through probate in order to get, title to their home, which is crazy, that you would think to have to go through that process. But, that's why, these little things, little mistakes can cause these huge consequences, and why you really want to get ahead of it and utilize the resources and the access that you now have by, talking to someone who can guide you through, those types of decisions.
Well, picking up on that discussion around real estate, how can families handle real estate or family businesses? There's so many of us that have small businesses now. How can we handle that in a way that reflects everyone's interests and expectations?
Right. So it's going to depend on the nature of your assets. So if you have multiple real estate properties, for example, there might be another strategy that we would recommend, which may include setting up an actual legal entity or entities like LLCs to hold the property, so that, if you are renting out property and, you want to make sure that you're protected from a liability standpoint, if someone were to sue you, there are different strategies around that. And if you do have an LLC or LLCs or business interests, as you mentioned, just in general, it doesn't have to be related to real estate. It could be any other type of business. That is an asset of your estate. And another very common mistake that we see with respect to business owners is their businesses are not properly folded into or incorporated into their estate plan. So when you have a business, just like any other asset, it needs to be part of your estate plan, and there needs to be a transfer and assignment of those interests. So there are legal documents that need to be drafted so that if and when anything happens to you, that business, its assets, its accounts receivable, any interest that you have are properly funded or put into your trust. So that kind of brings me to another part of the conversation about funding your trust. So, and again, this is rife with mistakes. It's almost like a minefield where you just don't know, when you're going to step, on a bomb. So when it comes to funding your trust, think of your trust as a box, right? So your box needs to hold all of your assets. So your real estate, your business interests, your bank accounts, retirement accounts, life insurance, your personal property, your crypto, all of your assets, anything that you own, you want to go inside of the box, because anything outside of the box is going to be subject to probate. So if you have a trust, and this we see oftentimes, sometimes people have a trust and they may have some of their assets that are titled in the trust, but there might be some assets that are left out. And if there is any asset, or if there are assets that are left out of the trust, your estate becomes subject to probate. And you would still have to go through that probate process, even if you actually have a trust. So the best thing is to make sure that everything goes inside that box. So anything that has a title to it, if it's in your name or in someone else's name, it's subject to probate. you need those assets titled into the name of the trust. And what that process looks like is going to vary depending on the type of asset. So if you've got real estate, as we were talking about, the deeds need to be prepared and drafted in such a way that the trust is the owner of the real estate. Now, you're still ultimately the owner as the grantor and as the trustee, but this allows us to bypass the court process that we talked about earlier. We can bypass probate by having assets titled in the name of the trust. So that funding process includes retitling, re-registering, updating beneficiaries, transferring and assigning any assets or interests that you have into the trust. Now, this can be a little confusing. It can definitely be tedious. It can be a time-consuming process. So we do offer the service of doing that for you so that we're doing the heavy lifting and you don't have to worry about it. You know that it's going to get done correctly and you don't have to waste your time, spinning your wheels, trying to get, through to this financial institution, filling out paperwork or potentially not doing things correctly. So that is also something that's unique with respect to our firm. We do offer that service where many firms don't.
Full service is what I'm hearing. The Young Law Firm is literally full service. And so I guess I'll wrap up this particular episode by asking, what did I leave out of the box? What question should I have asked about families and family planning when you think about estates, trusts, and wealth?
I think, we could talk about this for hours, right? But I think it's important, especially when we're dealing with families and blended families in particular, that we're making certain elections when we're doing the design of the plan that are going to benefit and protect both sides of the family. So there are different provisions and sub-trusts. I mentioned a family trust. It's also known as a credit shelter or bypass trust. The benefit of that within your plan structure is, in a blended family, for example, the decedent, whoever dies first, that family's interests are still protected, and also we're able to avoid estate taxes. We're able to get the advantages of, so many different things as far as planning techniques. So I think, for blended families and families in general, making sure we're taking the steps now and also before the laws change as of December 31st, 2025, which will be here before you know it, that really high tax exemption is going to be lowered. So we need to plan ahead for, all of these different contingencies and planning sooner rather than later.
That's real. And actually, I lied. Another question about this, because you bring up, December 31st, every 4 years we have an election in this country in particular. And in addition to the annual check-in on, just making sure you're updating your assets and your documents, should you also pay attention to new administrations as they come in and any laws that they put in place or how that may change from administration to administration?
Yes. And that's really our job, right? That's why, being part of that VIP membership is such a great value add for our clients. And about 90% of our clients are actually part of our VIP program. So as things do change, we're the ones, that are able to say, hey, this is on the horizon. These are the things that you should be, considering and thinking about. Here are some adjustments that you might consider making because these are the consequences. These are the other outcomes that could be the reality if you don't. And another thing that we do is we send out newsletters with, updates, changes in the law, things like that. So, we're constantly, part of that ongoing relationship, where we're cultivating that and that trust, because we want you to, be at peace and know that your plan is going to work when your family actually needs it to.
Yeah, when they need it to work. Right. Well, Shane, lastly, if there's one piece of advice that you would encourage listeners to act on from today, whether you're a young family, whether you are a blended family or you're a mature family, what would that advice be?
My advice would be to do something now, even if you think that, estate planning isn't for you. If you're over 18, it is. So utilize these resources. Thankfully, Angela, through this podcast is providing such great information and resources. We've got that webinar, so you can access that on the website. You have that complimentary session that we're offering, plus the discount because you are part of the podcast audience and, this group, thanks to Angela. So, take advantage, don't put it off, don't procrastinate, just take that first step and then we'll be there to guide you.
Yes, take that first step. That is certainly a huge takeaway from today's conversation and this ongoing discussion that we've been having around estate planning and elder care. Shane, thank you once again for informing us, providing us a little bit of, I think, safety, right?
Mm-hmm.
Just, it feels safe to start having these conversations. And I appreciate you for kind of being able to distill this complex and nuanced practice with myself and certainly our listeners. And it's so great having you on Unlocking the Club. Thanks for sharing your expertise.
It's my pleasure. Thank you.
Awesome. All right. That is it for another special episode of Unlocking Club, where again, we start to unpack estate planning and elder care. Today, we had on special guest Shane Jasmine Young from the Young Law Group. Make sure you take Shane up on her offer. I can't tell you how much value you will get out of that offer. We'll make sure that you have access to that in our show notes, on our website, and in all of our social media pages. Again, grateful for the experts that we have in the room and in the space and in conversation with us here on Unlocking the Club. For another episode of Unlocking the Club, I'm your host, Angela Taylor. It's an honor to be in this space with you. And until next time, be well.
Thanks for listening to Unlocking the Club. If this conversation resonated with you, subscribe to our podcast on iTunes or your favorite streaming platform so that you can experience every episode. And follow us on social media, where you'll hear about future guests, access special features, and connect with this amazing community. Head on over there and let us know how you are unlocking the club. Until next time, peace.